We were just looking at on the question of the procedural obligations of the tribunal and the flexibility in the tribunal. We were looking at the Act. It's probably worth just doing briefly the rules, which are at 312 towards the back of the bundle. The first point in passing, as it were, if you look at 313 on Lord Clark's point, you'll see in the definitions in the rules, paragraph 2 at the top of 313, that the rules do distinguish procedurally between the complaint, which is the statutory form of grievance, and Section 7 proceedings. And later on in the rules say how you bring each different type of claim, proceedings and complaints. So they are distinct under the rules. The important rules are 6, disclosure of information, which sets up an unusual disclosure regime. 6.1 is the embodiment in the rules of the statutory principle that we saw. The overriding consideration is not to disclose certain types of information that may have certain consequences. That's the not confirm or deny rule. Then at 2, there are a list of things you can't disclose to the complainant or to any other person, including the fact the tribunal have held or proposed to hold an oral hearing, any information or document disclosed to the tribunal in the course of the hearing, any other information or document disclosed to the tribunal, E, the fact that an information, document, identity or opinion has been disclosed. And then at 3 over the page, that you can disclose it with consent in the case of the appropriate person. And 4 provides a little bit of flexibility in terms of the notification of the determination. You can disclose anything described in paragraph 2, not during the course of the proceedings as part of the trial procedure, but as part of the information provided to a successful complainant in whose favour a determination has been made. We'll see that in 13.4 and 5. But 5, the tribunal can't order any person to disclose any information or document which the tribunal themselves would be prohibited from disclosing under their overriding obligation. Then 9, we have the rule on the forms of hearing and consideration. 9.1, there's the flexibility to determine procedure subject to the constraints of the rule and the Act. No duty to hold oral hearings, that's 2. May hold separate oral hearings, so they hear from the complainant separately from the respondent. And then 6, the rule that caused the problem in the case where the IPT ruled on its own rules. All hearings, including oral hearings, should be conducted in private. In that hearing, in that decision where it looked at its own rules, it said that was the one that was inconsistent with Article 6, because you couldn't in all circumstances say you'd have to have private hearings. For example, rulings on points of law, the IPT now does in public. And then at 13...
How did they get... I mean, I know that that's what happened, but how did they achieve that?
How did they achieve it?
No.
It's a little. They achieved it by asking themselves whether the rule had been
No. But having decided that they needed to hear points of
Yes.
law in public, how did they overcome this rule?
They said it hadn't been as I read the decision. It's a little difficult to follow. They said it hadn't been lawfully made according to public law. Because of Article 6, but that it hadn't been lawfully made by the Secretary of State. It was too wide because it wasn't compatible with Article 6.
I see.
Yes, they said it was. They did say it was ultra vires.
Because it was only a rule, they could read it down themselves.
Yes.
I see.
Yeah.
Read it out.
Read it out. Well,
They said they did say it was ultra vires. They say the rule had not been lawfully made by the Secretary of State under the rule-making power because in its width it necessarily conflicted with Article 6. where the decision as to whether to have a private hearing had to be fact-sensitive. You had to look at the justification for having a private hearing in every case. And then 13, notification to the complainant. There is, in 2, a relaxation of the "you just get told what the result is" rule in the statute. It says, where they make a determination in favour of the complainant, the tribunal should provide him with a summary of that determination, including any findings of fact that it can give. But there's no mitigation of the statutory rule as far as losers are concerned. You just get told that you've lost. They don't give you any reasons and don't give you any facts. So those are the rules, and Mr. Panick's going to address them in a bit more detail. I don't want to duplicate effort. You'll have seen there's some considerable argument in the Justice case about Article 6 and the rules. I'll just briefly in a moment say our piece on them and leave them to him. So we were, before we got on to the statutory materials, just finishing off my summary of our argument. We were on paragraph 7, or coming to paragraph 7. So if we're right in everything above, we say that the word "only" must mean something other than exclusive jurisdiction. In section 65(2)(a), we say, as Justice say in their case, that it's plainly declaratory, and what it does is that it makes clear that in the event that section 7(1)(a) claims falling within subsection 3 are to be brought in a tribunal, in the sense of a specialist judicial body which is not an ordinary court, it will always have to be in the IPT. That will be the only tribunal that would ever be appropriate to consider such cases, and we say that makes sense because the IPT is on subject, as it were. It's used to dealing with the issues in the sorts of cases that we're looking at involving investigative powers. And therefore we say Mr. Justice Collins and Lord Justice Ricks got it right, and that if the admin court was seized of section 7(1)(a) claim and the challenge was made, as in this case, that it should be in the IPT, well, it could decide whether to decline jurisdiction. And then we deal at 9 with our third meaning, which I'll come on to in due course, and the last resort, which is Human Rights Act section 3, that you have to read into, if my learned friend is right about his construction, as the inevitable construction of 65(2)(a), you have to read into it a freedom to us to pursue our Article 10 complaint in a court without that restrictive procedure that we've seen. And I'll explain why in a moment, that is a result that you're driven to under the Article 10 case law. What I haven't done yet is look at Shayla, and I just want to look briefly at that for the obvious reason that it sets out the shape, as it were, of the case that my client would be running, at any rate in the admin court. What's the reference to Shayla? Just give me a second. Volume 4, tab 32, please. As you'll see from the head note between E and F, Mr. Shayla had in 1997 disclosed a number of sensitive documents to a national newspaper. He was a former member of the security service. He left the country, and in August 2000 he returned to the country and faced proceedings for disclosing documents or information without lawful authority, contrary to sections 1 and 4 of the Official Secrets Act, 1989. And the issue arose in the criminal proceedings whether the Official Secrets Act restrictions that Shayla was under as an ex-member of the security service were incompatible with his Article 10 rights. It arose at a preparatory hearing in the Crown Court. The House of Lords held that those restrictions, the confidentiality obligations under the OSA, were necessary and proportionate restrictions, precisely because somebody subject to the Official Secrets Act could seek lawful authority before disclosing, whether as a whistleblower to another law enforcement agency or a politician or something, or ultimately to the media. And that that person could judicially review if the power to authorise was exercised incompatibly with Article 10 principles. And we rely principally upon, in the speech of Lord Bingham at paragraph, with whom the other law lords agreed, at 21, paragraph 21, a well-known and oft-cited passage quoting the importance of the Article 10 right to freedom of expression, where the material that's being written or communicated is about the business of government. He says that the business of government is not an activity about which only those professionally engaged are entitled to receive information and express opinions. It is or should be a participatory process, but there can be no assurance that government is carried out for the people unless the facts are made known, the issues publicly ventilated. Sometimes, inevitably, those involved in the conduct of government, as in any other walk of life, are guilty of error, incompetence, misbehaviour, dereliction of duty, even dishonesty and malpractice. Those concerned may very strongly wish that the facts relating to such matters are not made public. Publicity may reflect discredit on them or their predecessors. It may embarrass the authorities. It may impede the process of administration. Experience, however, shows in this country and elsewhere that publicity is a powerful disinfectant where abuses are exposed. They can be remedied. Even where abuses have already been remedied, the public may be entitled to know that they have occurred. And then over the page, at 2 pages on at 29, in Lord Bingham's speech, he expresses the hope that if disclosure were made to one or other of the persons listed above, they're listed at paragraph 27, staff counsellor, so on and so forth. Whistleblowing disclosures, basically. One would hope that effective action would be taken, but the possibility must exist that such action would not be taken when it should be taken, or that despite the taking of effective action to remedy past abuses and punish past delinquencies, there would remain facts which should be in the public interest revealed to a wider audience. This is where, under the OSA 1989, the second condition comes into play. The former member may seek official authorisation to make a disclosure to a wider audience. And then a very important passage at 30, picking it up at F. If the information or document in question were liable to disclose the identity of agents or compromise the security of informers, one would not expect authorisation to be given. If, on the other hand, the document or information revealed matters which, however scandalous or embarrassing, would not damage any security or intelligence, impede or interest, or impede the effective discharge by the service of its very important public functions, another decision might be appropriate. Consideration of a request for authorisation should never be a routine or mechanical process. It should be undertaken bearing in mind the importance attached to the right of free expression and the need for any restriction to be necessary, responsive to a pressing social need, and proportionate. And then at 31, you get the endorsement of the possibility of judicial review as the remedy for the former member who is complaining that the request for authorisation hasn't been determined in that way. If you look over the page at 272A, in considering an application for judicial review of a decision to refuse authorisation to disclose, the court must apply, albeit from a judicial standpoint and on the evidence before it, the same tests that are described in the last paragraph. We'll also bear in mind the importance attached to the Convention right of freedom of expression. We'll also bear in mind the need for any restriction to be necessary to achieve one or more of the ends specified in Article 10.2. and again to be responsive to a pressing social need and proportionate. And then in my Lord Hope's speech at paragraph 72, there is again a recognition of the importance of the availability of judicial review. The scheme of the Act, this is on page 284, does not stand alone. Any decision to decline an official authorisation will be subject to judicial review. The European Court of Human Rights has recognised in the context of a complaint of lack of impartiality in breach of the Article 6.1 Convention right, the value which is to be attached to a process of review by a judicial body that has full jurisdiction and provides the guarantees of that article. And there's a reference to Bryan, United Kingdom, Kingsley and Porter and McGill. I would apply that reasoning to the present case. An effective system of judicial review can provide the guarantees that appear to be lacking in the statute. There's a reference to the implicit problem of disclosing for the purposes of the judicial review. But at 73, my Lord says the procedural point can, I think, be met by the authorisation system itself with judicial review with regard to it as the ultimate safeguard. And so it was accepted that you could disclose to your lawyers, for example, for the purposes of the judicial review.
Well, if you're wrong about this and the matter has to go before the IPT, no doubt all this will be very valuable reading for that tribunal, as to their approach to the matter.
Yes, absolutely. But I mean, equally, it would be the shape of the case in the admin court as well, but without the procedural restrictions. I just want next, if I may, to go back to the core volume and have a quick look at section 7.2 for a point that we didn't look at it before. It's at page 144. This is a point that's well made in Justice's submissions. It's 146. We looked in subsection 2 of section 7 at the first half of the subsection before the semicolon dealing with appropriate court or tribunal. But it goes on to say, and proceedings against an authority include a counterclaim or similar proceeding. Now, the reference to proceedings against an authority is clearly a reference back to section 7.1a, the section 7.1a type case. What it opens up is the possibility that you're subject to a claim in the courts. You can then counterclaim under section 7.1a. You can bring your Human Rights Act claim under 7.1a by way of counterclaim. Now, this sets up an anomaly on the Respondent's interpretation of section 65.2a, because if the intelligence services are suing you, they have to sue you in the courts. The IPT has no jurisdiction over claims by the intelligence services. So, to take an example, just again, a hypothetical example, supposing you take objection to the security services spying on you, you go outside into the street and you set fire to their van with thousands of pounds worth of surveillance equipment in it. If they want to sue you for the damage to their equipment, they have to sue you in the courts. If they sue you in the courts, you may want to counterclaim saying they were acting unlawfully under Section 8 in spying on you in that way. But if you did that, you'd have to go to the IPT to bring the counterclaim on the Respondent's interpretation of Section 65.2a. And that seems to us a slightly odd, if not absurd, outcome, given the language of Section 7.2.
So if you were raising the matter as a matter of defence, not as counterclaim, then the court would have jurisdiction. As well,
under 1b. All of which keeps coming back to Lord Justice Ricks's point, what's so special about the 7.1a claim, the Human Rights Act claim being taken under 7.1a as a sword. I did want to have a look at 3 Article 10 cases, because it's important not to lose sight of the fact that this case is about the right to freedom of expression, and there are particular requirements under Article 10 that apply when the state is taking decisions that interfere with freedom of expression. The first and perhaps best known of the requirements was originally, I think, expressed in the Judicial and Denmark case, which is in Bundle 8, so it is Volume 8, at 70. It's a case about a television program in which some young racists were interviewed to camera, but the facts aren't particularly important. If you turn to page 26, my lords, paragraph 31 in the judgment, right in the middle of the page, the Strasbourg Court discusses its role in reviewing an Article 10 case. What it says is this: the court will look at the interference complained of in the light of the case as a whole, determine whether the reasons adduced by the national authorities to justify it are relevant and sufficient, and whether the means employed were proportionate to the legitimate aim pursued. This is the important part. In doing so, the court has to satisfy itself that the national authorities did apply standards which were in conformity with the principles embodied in Article 10, and moreover that they base themselves on an acceptable assessment of the relevant facts, which is Eurospeak for saying if a court upholds an interference with freedom of expression, you've got to set out reasoning which is consistent with Article 10 principles and standards, and show that in applying the facts and making the value judgment, you have done it properly. You have made a realistic and a proper assessment of the facts. The court has considered the banning of, I'll come back to that in a moment, and we'll see how it resurfaces in the procedural requirements under Article 10. The court has considered state powers to ban books and the risk that they are abused, and also emphasised the need for an effective judicial review to prevent such abuses by the state. And if you take up, my lords, volume 6, you will see the case at page 47 of Association Ekin versus France. This was a case about an administrative decision by the Ministry of the Interior in France to ban a Spanish book, a book of foreign origin under a French law, which was distributed in France about the Basque cause. And the book was banned on the basis that because of its content it would impose a threat to public order. The book was banned in 1988, and it wasn't until 1997 that the administrative court, the Conseil d'État, overturned the ban, the senior administrative court. And you can pick up the reasoning of the European Court at paragraph 19. It looked at the reasons in the Conseil d'État for quashing ultimately quashing the judgment and the ministerial order. So after some 9 years, the French state finally effected the content of the publication. See at the end of the indented paragraph, didn't provide...
Which paragraph?
19.
Yeah.
This is where they got to after 9 years. The Conseil d'État finally accepted that the book shouldn't have been banned, last 3 lines of the first paragraph, because its content didn't provide sufficient legal justification for the serious infringement of press freedom embodied in the impugned decision. There was a problem, which was that prior to that, the public law that the Conseil d'État applied in cases like this didn't allow it sufficiently intensive review to reach a decision like that and to actually scrutinise the contents of the book. So if you turn on to 46, you'll see that the Strasbourg court said, well, when the original banning of the book took place, it wasn't in a framework that was sufficiently prescribed by law. It was ultimately, after 9 years, when the Conseil d'État was willing to look at the contents of the book properly. But if you look at the bottom paragraph of 46, the earlier limited review by the administrative courts, the court was inclined to think that the restriction complained of didn't fulfil the requirement of foreseeability. That's the prescribed by law requirement. Then at page 16, paragraph 56, the court's assessment on the justification for the ban, right at the bottom of page 16, it reiterated a fundamental principle under Article 10, dating back to the Observer and Guardian versus the UK case, right at the last 4 lines of page 16, the dangers inherent in prior restraints, which of course this case is, A's case, are such that they call for the most careful scrutiny on the part of the court. This is especially so far as the press is concerned, for news as a perishable commodity, and to delay its publication even for a short period may well deprive it of its value and interest. And then at 57, the court considers these principles apply also to the publication of books in general and written texts other than the periodical press.
I'd be enormously helped if you've got a Strasbourg case that's got anything to do with this in the context of security.
There is one, but it's not a book. It's not exactly on that, but it's about the standards of visibility and transparency that should be apparent in the decision to uphold the restriction on freedom of expression, where national security is the reason put up against it. And you'll see at 58 that the court says that in the second half of that paragraph, that such prior restraints are not necessarily incompatible with the Convention as a matter of principle. Nevertheless, a legal framework is required ensuring both tight control over the scope of bans and effective judicial review to prevent any abuse of power. At paragraph 61, it found on the facts that the long delay in allowing the publication of the book didn't provide sufficient guarantees against abuse, that the contents of the book weren't looked at properly over the initial 9-year period, so that the ban was unjustifiable on the facts. And there was a violation of Article 10. There was also a violation of Article 6, because it was a dispute over civil rights and obligations, and the delay also meant that there was a breach of Article 6. The case I was referring to is at volume 8, page 72. Sorry, tab 72. This was a case, it wasn't a book, it was a newspaper that was closed down on national security grounds and public order grounds for advocating or supporting a breakaway republic in Moldova. So there was a denial of publication in the name of national security, and it was closed down by the courts on the application of a public prosecutor because of that content.
What's the name of the case?
Commissant Moldovi versus Moldova at tab 72.
Well, somebody seems to have given me all the other tabs except tab 72. But never mind, I'll muddle through with that.
That may be because it's the only case I can point to in response to Lord Brown's question of whether there's a case on national security. You'll see at 5, the applicant newspaper published a series of articles in June to September 2001 criticising the authorities of Moldova for their actions in respect of a breakaway region of Moldova, Transnistria, or MRT, and criticising the government and the Russians. And at paragraph 8, the Prosecutor General took court proceedings against them for endangering through its publications national security and territorial integrity, together with public safety and order in Moldova, lending open support to the unconstitutional regime of this breakaway republic, etc. And you can see what's coming. You get it at paragraphs 36 to 38. Essentially, the courts in Moldova upheld the position of the public prosecutor. Sorry, I should have taken you to this at 11. There was no, because it is important. First of all, the Economic Court, which is the lower court, accepted the public prosecutor's contention that the content presented a risk to national security.
Which paragraph are we on now?
I'm so sorry, paragraph 11 on page 3. This is at the first instance court. The court did not specify which expression or article constituted a threat and gave no further detail. It added the articles could not represent a fair summary of public statements by public authorities, and so there was no immunity under another Moldovan law. The applicant appealed. The appellate chamber of the Economic Court upheld the lower court's judgment, repeating the arguments of the lower court, saying it had correctly assessed the facts and simply correctly decided there was no violation of Article 10. It's paragraph 13. And then 14, the Supreme Court upheld both judgments, essentially repeated the reasoning of the Economic Court and found the applicant had exceeded the limits of restrictions on freedom of expression determined in Article 4 of the Press Act through some of the publications annexed to the file which undermine national security, territorial integrity and public safety. But as I say, you can see what's coming. It didn't really do what judicial says you have to do, which is to properly assess the facts, look at the content of the articles and actually articulate in your reasons for upholding the interference why there is actually, on the language used and what's published in the book, such a threat. And so the court says, at paragraphs 36 to 38, the court considers the domestic courts did not give relevant and sufficient reasons to justify the interference, limiting themselves essentially to repeating the applicable legal provisions. In particular, the courts did not specify which elements of the applicant's articles were problematic and in what way they endangered the national security and the territorial integrity of the country or defamed the President. In fact, the courts avoided all discussion of the necessity for the interference. The only analysis made was limited to the issue of whether the articles could be considered as good faith reproductions of public statements for which the applicant could not be held responsible in accordance with the domestic law. In light of the lack of reasons given by the domestic courts, the court is not satisfied that they met the Jursild test and applied Article 10 standards in upholding the interference. So you have to give reasons under Article 10, let alone Article 6, which show that you've done the Article 10.2 exercise properly. You have to give them to you must give them to the person whose right is being interfered with.
But I mean, the national security interest there was all different. I mean, there's no question of giving away secrets. It's a question of encouraging subversion.
No, but the principle must be the same one. If you're interfering with somebody's freedom of expression, so you're getting, let's say you're in the IPT, as you have to be on Malone Friend's case, you get an adverse decision. There has to be an articulated set of reasons under Article 10.2. Fine, but it has to be visible. It has to be visible and it has to be communicated to the person whose human right is being violated. And that won't happen in the IPT. My client won't know why he's lost, won't be able to say whether...
What if the reasons themselves, or giving the reasons themselves, would be damaging to national security?
Well, what you have to do, and Learned Friend's going to deal with this under Article 6, is you have to find a way of communicating the analysis to the complainant without causing that problem. And you have to look on the facts of each specific case about how it can be done. But in this case, the complainant is not a member of the public. The complainant is subject to a duty of confidentiality in relation to the information that's being considered, and he has shown himself willing to adhere to that duty of confidence. That's why he's asked for authorisation. So whatever might happen in another case, there can surely be no risk in this case in saying, we give you the reasons, we give A the reasons, on the basis that they're confidential. They're not... Yes, and we've made the point in the case that a lot of that stuff will not be new to him anyway, because they've had this dialogue for 2 years about what should and shouldn't be in the book. And he has always respected his obligation of confidence. The value to him of those reasons will not be that he's able to go and communicate them to the public, but it will be that he knows why his Article 10 right has been denied, and he'll be able to communicate with his lawyers about taking a case to Strasbourg. I mean, he can't take the case on appeal by way of judicial review if he loses in the IPT, but he can go to Strasbourg. And so at the very least, there must be that communication of proper reasoning. But one accepts that's a balancing act. In ordinary cases, how much can you say without endangering national security? There's no dispute about that. But on the facts of this case, it doesn't seem to us that it's as problematic as in other cases. And there must be some mechanism for enabling the applicant to know whether he should be pursuing a case to Strasbourg. That's basic fairness. Article 6, I will leave to learned friend Mr. Panic to deal with, because it's been pretty thoroughly dealt with in Justice's case. I mean, obviously what we would say is we do understand that the court is reluctant to adjudicate on Article 6 in advance of the actual hearing in the IPT. You don't know what the end result will be, you don't know how it'll pan out. But it does seem to us, as Justice say, that there are some inevitable violations of Article 6 in the procedure that we've looked at. And our principal concerns are threefold, and you'll be familiar with them already. First of all, there's no guarantee to us of disclosure of the case that we have to meet. That will be subject to the consent of the other side. There's nothing the tribunal can do about that if the other side don't consent. We won't know the case we have to meet. We get no reasons if we lose. 2, and we can't appeal or judicially review.
Well, that might be an advantage. You might win. They can't appeal. Why is it necessarily a disadvantage? You assume you lose.
Well, we have to contemplate the possibility. That we lose. And the issue is not so much whether we will lose or not, but where would we rather lose? You know, would we rather lose in the High Court, or would we rather lose in the IPT, where there is no flexibility as to the giving of reasons, whereas there is some flexibility in the High Court. Our argument, our initial argument is what we're calling meaning 2. It's the interpretation of Mr. Justice Collins and Lord Justice Ricks, and you have that. We've dealt with that. The only point we would make is that if we're right that, en passant as it were, if we're right that there is inevitably some deficit under Article 10 and Article 6 in the procedures in the IPT, then keeping open for us the possibility that we can go to a court that may give us a more substantial degree of procedural fairness is important in terms of how one interprets 65(2)(a). It's the principle of legality articulated by Lord Hoffman in the Ex parte Sims case, and so by the law lords in Morgan Grenfell, that if there is a risk, if the consequence of one construction will be necessarily violations of human rights, Article 6 or Article 10, the court must lean against that construction. And we do say, as justice do, that that is the consequence of the respondent's construction. The anomalies on the respondent's construction we've dealt with in our case rather more fully than I want to in oral submissions, because time is limited. Can I just refer you to the passage in our case? It's section E.
Paragraph 49 is your construction number 2.
Yes.
Paragraph 24 is E.
Yes. Great.
Are you going to?
In fact, the anomalies are not just limited to the ones identified by Lord Justice Ricks, the what is so special about the HRA 71A claim, that it has to be caught in this way. There are other anomalies, notably that at 24.3, there are all kinds of other potential A's, because people in the position of A, who may want to publish a book that has national security implications in the contention of the Crown, but they're not required to go to the IPT. In order to ensure that national security is protected. They can go to a court, and we've instanced police officers in counter-terrorism investigations and special forces as examples of such Crown servants. So that anomaly is what's so special about the ex-intelligence services officer, that he has to be caught in this way. And then obviously at 5, we've also mentioned the injunction point, that if you don't ask for permission, and you do a Peter Wright, if I can put it that way, and say, I'm going to go off to Australia or America and I'm going to publish my book from there, and an injunction is applied for in the courts of this country by the Crown, the same argument is raised on your behalf under Article 10. It's just by way of defence to the injunction proceedings, and it's in a court. So that's an obvious anomaly. Again, no difference in the content of the evidence or the argument, but you end up in a court if you don't ask for authority, but in the IPT if you do.
I suppose that's right, is it? I mean, I don't know. I mean, if there's an injunction sought against you on absolutely categoric contractual grounds, you've breached your undoubted undertaking, etc., not to publish, and then wouldn't there have to be some public law process to challenge it? You may be right, I'm not sure.
Would a court stay a decision on the injunction holding that you ought to go under section 5(2)(a)?
Well, I suppose that because the framework, as Lord Clark pointed out, is the obligation of confidence, then as in the Spycatcher case, the initial move would be to get an injunction relying on the obligation of confidence and simply to enforce that by way of injunction. And that would be done quickly, no doubt, by way of a swift application.
And then to challenge that, you would have to surely make good your public law case, which is either, if you're right, by judicial review or by the IPT.
Not sure you would. You're in a 7(1)(b) situation, aren't you? There, you're actually using the argument under Article 10, freedom of expression, in your own defence on the issues at stake in the interlocutory injunction application. You're facing the proceedings and simply saying the court should not exercise its power to grant an injunction.
You'll be relying on the convention right in the legal proceedings brought for the injunction.
Yes.
As long as you didn't make the mistake of counterclaiming your declaration, you'd be all right.
Yeah. Well, No, you could counterclaim for a declaration in the courts. You could do that as well.
Could you?
Yes.
Wouldn't you then be stuck with...
No, that's section 7.2.
Yeah, then you'll be the wrong end of the second limb of 7.2.
You'd be the right end of it. You can counterclaim in the courts.
No. Proceedings against an authority include a counterclaim.
under 1A.
Under 1A.
So you just had to be very careful not to count it.
Oh, I'm so sorry. Yes, you would. Yes, then you'd have to. Yes, exactly. If my Lord is absolutely right.
There's a difference
if
between
you pleaded
defences
as a
and
counterclaim, you'd have to up sticks and go off to the IPT. Yes, I beg your pardon. You'd have to up sticks and go off to the IPT. To
Yes,
run
but if the only thing you were going to counterclaim is a declaration, you wouldn't need the declaration, so you just...
No, exactly. But I mean, in reality, the contest would be over the injunction. Will it? Won't it be made as?
Your point is this makes a nonsense of the whole thing.
It makes a nonsense of any suggestion that the IPT has to have exclusive jurisdiction in these sorts of situations.
Are there any circumstances in which a claimant, such as your client, would want to go to the IPT?
No, I don't think so. I mean, it's interesting. I don't know if you looked at C versus the police, but what happened in that case was the police officer who was mowing his lawn insisted that the IPT had jurisdiction. And the police authority said it didn't have jurisdiction and the appropriate place was the courts. But I don't think there'd ever be an Article 10. I mean, I suppose the my learned friend would say the one example is where Section 17 of REPA comes into play, which is the absolute prohibition of putting into evidence in cases anything indicating that there's been an interception of a communication or the content of the communication, debugging. Which is a long-standing principle in our law, and it's found again in Section 17. So I suppose that's the one example where if you thought your Article 10 case required some disclosure, contrary to Section 17, you might prefer to go in the IPT. But that's not the situation here. My client's strong preference is to go in the courts, so that's not a consideration in his case. But yes, I can see that as the one, and my learned friend makes that point in his skeleton argument.
Well, he also makes a point, I mean, it's an associated point, that actually you've got a whole lot of rules to deal with all the problems of disclosing secrets in the IPT, and you've got nothing equivalent, and this is Lord Justice Dyson's, one of his main points,
yes.
Nothing equivalent in the courts.
Yes.
But I mean, the Section 17 REPA point is just, it's the same idea.
Yes. It's the same idea, but equally there are in all these other all these other situations, and there are many others, as we know, where the High Court has had to grapple with national security considerations. The Binyam Mohammed case being the most recent example, and it has adopted procedures to protect the concern about the no confirm, no deny policy. And is well able to do that. And that seemed to be implicit in the House of Lords decision in Shaler, that it was recognised that a judge in the High Court could manage that sort of thing. And the problem, of course, with Lord Justice Dyson's point is that if the jurisdiction that you're looking at in the High Court is a specialised statutory jurisdiction like the one that the High Court inherited from SIAC to supervise control orders, it's easy to formulate a set of rules, or it's relatively easy to formulate a set of rules on the back of what's in the statutory regime, as has been done with the IPT and REPA. But there is an infinite variety of other cases that may be brought in the civil courts. If we're right, raising Human Rights Act points, but where there are national security considerations. And it's not so easy to draft a fixed set of rules for that infinite variety of cases, is it? You must inevitably leave it, to some extent, to the court to manage the procedure in that case according to the facts of the case, surely. So it's really not that odd, we would say, that in this context there aren't special rules in the White Book, in the CPR, because you'd be predicting an infinite variety of cases. I'm very conscious of the time, Lords. Yes. I did promise possible time to finish. Right, yes. Can I just mention, there are two other important Article 10 cases. They're along the lines of the ones that we've looked at, but they're in Volume 7, 61 and 63. In particular, try and find a way not to have to say it. Glass Nadezhda case versus Bulgaria at 63 does emphasise very strongly the need for proper reasoning in Article 10 cases, and indeed a breach of Article 13 was found in that case. There was a case about a religious radio station where a licence had been refused and there had never been any attempt to articulate the Article 10.2 justification. I didn't take you to it because it wasn't connected with national security, it was to do with religion, but the same principle runs through all of these cases. Finally, we have our meaning, our alternative meaning, but we don't, certainly not our primary case, meaning 3. We say that Mr. Justice Collins, Lord Justice Rick's approach is the correct one when you look at all the sorts of arguments we've been putting forward thus far.
Is this construction 3?
Construction 2, yes.
Sorry, 3 or 2?
2. We say 2 would be our primary case. It's our primary case.
You were just then going on to your
yes,
fallback under 3.
Exactly. If we fail on 2,
that's what I thought. Yes.
We ask you to consider meaning 3,
yes.
Which essentially is a purposive construction. We're inviting the court to consider what is the purpose of the IPT under that heading at the beginning of Part 4, read in the context of the Act as a whole and the reasons why the Act was brought into force. And it seems to us that there's nothing in the Act or the introduction of the Act that suggests it was ever intended by Parliament that a claim of this sort, under Article 10, to publish a book, would be forced into the IPT. It was simply never the purpose of the Act to achieve that aim. And it has the substantial disadvantages under Article 6 and Article 10 that we've identified. And it seems to us that you simply have to read proceedings in subsection 3A, in 2A and 3, as referring to activities, a Human Rights Act challenge to activities of the intelligence services in relation to their investigatory powers, which is what the Act is about, rather than this sort of high-level administrative decision about whether somebody can publish a book or not.
I mean, maybe this is an unfair question, but if this is where you get to by a purposive construction, and assuming you can do it intellectually with a straight face,
yes,
if that's right, why isn't it your first meaning? Because it means that the IPT has no jurisdiction, doesn't it? In the kind of case you say it wasn't intended to have jurisdiction. Whereas
yes,
your second meaning
yes,
has a sort of overlapping jurisdiction, which
yes,
is very peculiar, it might be said.
Well, you say yourself of the second one, a slightly unsatisfactory legislative outcome.
Yeah. Well, it might.
That's your preferred view.
Well, because you tend to strive for.
Maybe the moral of the story is never to say what you prefer.
Well, I'm always honest in my submissions and the way I draft my case, and it had been said lower down that was a slightly unsatisfactory outcome. Even Lord Justice Ricks expressed that view. But it seems to us that it's infinite, for all the reasons that we've given, even more unsatisfactory by way of outcome is the one that the respondent contends for, which is this claim gets forced into the IPT.
But can we just understand? Can we just understand then? If you're within the scheme of Section 65(2)(b) and subsection 4 and then subsection 5.
Yes.
We were looking at that and you took us through it in some detail. It's a relatively, well, it's a confined series of situations which are basically related to specific situations in the statute.
Yes.
Right? Whereas you're now saying that A is also related to situations within the statute, but do I understand you say in some way less confined? How, in other words, do you limit the scope of A, and in what respect is it any wider than
the limitations which would apply under 4 and 5.
Well, on this construction, you would be looking at cases that get framed as Section 7.1a cases, not to duplicate the substance of the complaint, obviously. If you can bring it by a complaint, you get through the statutory hurdles, you bring it that way. But there may be Article 8 violation claims that can't be formulated as complaints, perfectly on the words of the statute, or may be substantially to do with the activities, the investigatory activities of the intelligence services, for example, and therefore properly dealt with by the IPT. But the point about the third meaning is that if it isn't, as my Lord Clerk puts it, easy to make out on the face of the statute and the language of the statute intellectually, we come then to HRA Section 3.1. And if we're right that forcing us into the IPT with the 3 problem procedural areas that we've described is inevitable, that we can't get to a court at all to pursue our Article 10 complaint, then we say Article 3 comes into play and you must read Section 65(2)A in such a way as to allow us to bring our Article 10 complaint in the courts.
So, I mean, the basic argument is that this is covering roughly the same subject matter as complaints, but in circumstances where you can't actually find a ground of complaint in the statute,
yes,
but you can find it in the Human Rights Act.
Yes, you can frame a Human Rights Act complaint relating to the investigatory activities of the agencies covered by the Act.
Well, put that way, it sounds rather like a subspecies of subsection 2B, and it's rather odd that it comes as A and not after B, because its prominence is right at the very start of the subsection.
That's one possibility. I mean, you've always got the option of taking the substance of a complaint and framing it as a Section 7.1a case, haven't you? I mean, there's no reason why you can't do that. And as I say, if you look at a lot of the decisions, people do tend to plead in the alternative, as it were, to hedge their bets. But partly, I suppose, because of the complexity of the definition of complaint. You've got to go through all these statutory hurdles. Whereas it's much simpler to say, look, I was being spied on, or my phone calls were being listened to, and that is an interference with my privacy, and I just want to put you to your justification of it under Article 8.2. I mean, one can see the attraction of that from the point of view of the person coming to the IPT. So I'm not necessarily sure that it is that odd, nor am I particularly sure that it shouldn't come first. I mean, the assertion of the human right is a fundamental right. It's a constitutional claim, surely, and it would logically come first, and you should have the option to frame your claim that way. What we balk at is the suggestion that all of those claims have to be heard in the IPT. That's all we balk at. The meaning 3 is a stepping stone to HRA Section 3, is it not? If we fail on meaning 3 and we've failed on meaning 2, then it is an imperative, we would say, that this court has to protect our Article 10, our Article 6 rights by enabling us to pursue the claim we started in the admin court.
How do we do that?
Well, I mean, our suggestion is that it's read so as to exclude a claim in which the Article 10 right is asserted.
In any case where the Article 10 right is asserted?
Well, it must, yes, because on the construction that we've lost in up until this point, any limitation on the Article 10 right that falls within any of those categories, 65(2)A or 3, that comes within that regime, cannot be brought in a court, irrespective of the issue that's being asserted, the Article 10 issue that's being asserted.
So why isn't the IPT a court for that purpose? I mean, as far as Strasbourg, if the parole board is a court, why wasn't the IPT a court?
For the 3 reasons that I've given, that you have no guarantee of knowing the case you have to meet, you have no reasons at all if you lose, and you have no possibility of appeal or judicial review to cure those defects. And that is an insufficient protection against abuse of your Article 10 right.
The European Court has considered the IPT, has it, in some guises. or not?
It's doing so as we speak, isn't it? I mean, it's
Yes,
going to
it can
produce
be.
a result next year.
Yes. And as Malone Friend points out, the Commission, under the old system, before there was just a court, the Commission had considered the complaints procedure under the 1994 Act as well. But those were not in Article 10 cases. Strasbourg has never considered this issue. It's always been in the context of the use of investigatory powers.
And it's still not looking at a Section 10, an Article 10 case.
No, it isn't. It is a very unusual set of circumstances, but we do say that for our purposes, what you have to read into this regime, if we lose on meanings 1 and 2, is the right to take our Article 10 case before a court. We do say that.
So how would we redraw the clause, the contract, the section?
Well, I suppose the easiest way to do it under Section 65(2)(a) would be to say, save for cases under Section 7(1)(a), asserting the Article 10 Convention.
That's very brave submission.
Yeah. I mean, I suppose you could be a little more timid. Perhaps you just say it except in my case. That's as far as you need go, isn't it?
I think that's even better.
Well, I mean, I suppose the alternative is to frame it to
Well, the trouble is, if you can't formulate it in a sufficiently narrow way, then you're struggling.
Well, the most obvious way to formulate it is akin to meaning 3, which is simply to say that it's saving cases not involving the use or possible abuse of investigative power.
Well, sorry, that's a Section 3 applied to subsection 3A, isn't it? I mean, that's a 65(3)(a), torturing of the language, not 2A.
I'm so sorry, yes, it's 3A.
It is 3A. I mean, it's proceedings.
It's assuming this case falls under 3A.
Yeah.
And the route we need out of is out of 3A. Yes,
Yes.
I just point that's absolutely right. So it would be claims against the intelligence, intelligence services that relate to the use of their investigative powers. Those would be the cases that are caught by 3A.
It would catch your eavesdropped person whose love life was being investigated. I mean, if he wanted Article 8 as well as that they shouldn't have been listening or inserting devices or whatever it was they were doing, he'd be caught. He would have to go to the IPT, but not you say your chap. Is that how it works?
Yes.
Yeah.
I think I once said in one of the cases, and I can't remember which it was, but it was dealing with the conditions, the restrictions on needing evidence in rape trials, that if you were to operate Section 3, you had to, as it were, redraft the provision in a way that would meet the requirements of a parliamentary draftsman, and that was said to be going too far in the Gaidan case.
Yes.
And that's why it's not entirely frivolous to suggest that you might be able to say, as you might in Strasbourg, say, well, I'm invoking Article 10. I don't need to redraft the thing. All I need to say is it doesn't apply to my case because it would be incompatible with my own rights.
Yes. Which in the case, and I'm afraid I've forgotten the name of it, but my Lord will know it well, about cross-examining rape victims.
That's right.
Yes.
It's A, but I don't know who the other party was. Is it RVA?
Yes. The conclusion was reached by the House of Lords. There needed to be some, the possibility of some alteration to the strictures of the statutory scheme in the Crown Court, where necessary, to protect the interests of the defendant, to put his case properly. But as I recall it, there wasn't an agreed sort of perfect. I know, my Lord, in your speech, you put a suggestion forward, but there wasn't a perfect form of drafting.
Well, Lord Steyne produced a paragraph which he thought met the requirements, but it wasn't actually a redrafting of the provision, as I recall it.
But it often, I mean, Your lordships are entitled to press me on this, and in the way that you have. But ultimately, of course, the point about Section 3 is that it's there to protect the human rights, as a mechanism in the particular case, to protect the human rights of the person who's complaining, to protect my client. And the outcome that has to be achieved is that it's read in a way which protects the interests of my client. But I mean, I don't see Section 3 as requiring the person whose human rights are being violated, if you've got to that point, to be the parliamentary draftsperson to come up with the perfect piece of drafting, or have to do so in order to successfully invoke Section 3. That would be quite wrong in principle.
But your third meaning simply requires one to insert arising out of the use of the powers conferred by this Act, wherever you get claim or complaint or anything else, doesn't it?
Yes. Yes, exactly. Exactly. And if we can do it as a meaning 3 purposive construction, that's one way to do it. But if you can't, it's exactly the sort of situation that HRA Section 3 comes into play. If we're right about the damage being done to our Article 10 and Article 6 rights.
There's some oddity about 3, isn't there, anyway? Because 3A is incredibly general. B, one can see, adds to it, and I suppose C adds to it. But 3D, challengeable circumstances within 5, is supposed to be different, and yet, if you look at 5A, you come back to A again, conduct on behalf of the intelligence services. It goes round in a circle.
Yes,
or it's the same
which
point.
is a very odd piece. But you also come to a lot of other things as well.
You come to a lot of other things, but on the face of it, there isn't, one would expect F5 to be limited, but it's actually very general because of A.
Yes.
So that, I mean, your invitation in answer to Lord Phillips is read in those words in both places.
Yes.
Can you give the words again? I'm so sorry.
And simply that
Proceedings against any of the intelligence services
Arising
Arising
out of the exercise of the powers conferred by this Act.
out of the exercise of any of the powers conferred by this Act.
But of course, the key point about Section 3 is that it doesn't depend on the language of the section. If you've crossed the Rubicon of saying, well, we can't construe it according to ordinary canons of construction in a way that will protect the human rights of the claimant, then you're into different territory. And the only question is it possible without, as Lord Rogers eloquently put it, going against the grain of the statute to read certain words into it to protect the human rights of the claimant concerned. And it really doesn't seem to us that to read this formulation into it.
Which section is it? Section 3.
Section 3. I'm really looking at the Gaidan versus Godan Mendoza case, which is in.
Is it really the exercise of any of the powers conferred? Does the Act confer powers? Doesn't it regulate powers?
Regulate, yes, it does regulate, it's true. Volume 2, 14. 13, I beg your pardon.
Which section, subsection in the Human Rights Act is it?
Section 3.1.
Yeah, well, that's...
And it's tab 13, volume 2. I'm terribly conscious of the time, but the speeches of their lordships in the Gaidan case set out the way Section 3 works. In particular, at paragraph. I'm so sorry. Tab 13 in volume 2. In the speech of Lord Nichols, at paragraph 28, through to this is a very well-known and oft-cited passage. Paragraph 28 through to 33. One tenable interpretation of the word possible would be that Section 3 is confined to requiring courts to resolve ambiguities. Where the words under consideration fairly admit of more than one meaning, the convention-compliant meaning is to prevail. Words should be given the meaning that best accords with convention rights. This interpretation of Section 3 would give the section a comparatively narrow scope. It's not the view which has prevailed. It's now generally accepted the application of Section 3 does not depend on the presence of an ambiguity in the legislation being interpreted. Even if construed according to the ordinary principles of interpretation, the meaning of the legislation admits of no doubt, Section 3 may nonetheless require the legislation to be given a different meaning. See R versus A, the case that I referred to, 30. From this it follows that the interpretive obligation decreed by Section 3 is of an unusual and far-reaching character. Section 3 may require a court to depart from the unambiguous meaning the legislation would otherwise bear. And then, just in the interest of time, a bit further down at 31, between F and G, once it's accepted that Section 3 may require legislation to bear a meaning which departs from the unambiguous meaning the legislation would otherwise bear, it becomes impossible to suppose Parliament intended the operation of Section 3 should depend critically upon the particular form of words adopted by the parliamentary draftsman in the statutory provision under construction. That would make the application of Article 3 something of a semantic lottery. If the draftsman chose to express the concept being enacted in one form of words, Section 3 would be available to achieve convention compliance. If he chose a different form of words, Section 3 would be impotent. From this conclusion, it seems inescapable that the mere fact the language under consideration is inconsistent with the convention-compliant meaning does not of itself make a convention-compliant interpretation under Section 3 impossible. Section 3 enables language to be interpreted restrictively or expansively, but Section 3 goes further than this. It is apt to require a court to read in words which change the meaning of the enacted legislation so as to make it convention-compliant. In other words, the intention of Parliament in enacting Section 3 was that, to an extent bounded only by, quote, what is possible, the court can modify the meaning and hence the effect of primary and secondary legislation. Parliament cannot have, however, have intended that in the discharge of this extended interpretive function, the court should adopt a meaning inconsistent with a fundamental feature of the legislation. And a little further down, the meaning imported must be compatible with the underlying thrust of the legislation being construed. Words implied must, in the phrase of my noble learned friend Lord Roger of Earlsbury, go with the grain of the legislation. Nor can Parliament have intended that Section 3 should require courts to make decisions for which they are not equipped. There may be several ways of making a provision convention compliant, and that choice may involve issues calling for legislative deliberation.
Would it be right to say that your reliance on this principle is a somewhat sophisticated one? What you're doing is damage limitation, because even if one restricts the scope of the Act, you're still going to be met with some of the arguments you've been advancing for saying it doesn't actually comply with the requirements of Article 6.
Yes, but they are going to be advanced in a context, i.e. the complaint about investigatory
much more justifiable.
Yes, exactly. Yes. Exactly. I don't know whether I can assist any further. I'm conscious of the fact that I promised Lord Panic that I'd finish by 3. I haven't made that, I'm afraid, but those are our submissions.
Mr. Adden? No. Mr. Panic. Lord Panic, I beg your pardon. Lord Panic.
Lord Justice is very grateful to the Court for the opportunity to make brief submissions. We support the submissions made by my friend Mr. Miller. I want to focus my submissions, if I may, on the content and the relevance of the tribunal procedures, because it's our submission that your Lordship should seek to avoid a construction of Section 65 2A, which will compel those who are complaining of breaches of their human rights into a tribunal whose own procedures breach Article 6 and against whose decisions there is at least very considerable difficulties in bringing any judicial review. Before I develop those submissions, may I just mention three preliminary points which have been touched on this morning. The first of them arose out of the question of my Lord Phillips this morning, and that is the anomalous consequences of the Respondent's approach, given that it is open to the claimant to bring common law claims, that is outside the Human Rights Act, for example, for public law irrationality, for breach of confidence, possibly for trespass, for nuisance, maybe even for negligence, depends on the facts of the case, all of which claims may be supported in terms of the scope of the duty by human rights considerations, because of course the common law must be interpreted in the light of the convention outside the Human Rights Act. As Lord Brown mentioned this morning, Section 11 of the Human Rights Act preserves all of that jurisprudence and understanding.
Why is that such an anomaly? I mean, firstly, one's got the question, what is the scope of the word complaints, but let us accept that that should be read narrowly.
Yes.
Secondly, one has in D a provision which one might have thought was clearly intended to enable the Secretary of State to observe and deal with such anomalies if they became really problematic.
Well, he hasn't done so.
No, but he could do. The whole point is that the statute foresaw that it might be appropriate to bring other proceedings within the exclusive
Assuming
jurisdiction.
He did so, the relevance would be that Section 65 would then involve a policy of ousting what was the previous jurisdiction of the High Court, and that would require that this court should take a narrower approach to the scope of Section 65 2A. That would be the relevance of it. And my second answer is that at the moment there has been no exercise of that power, and one is in the very odd position that the respondent has to explain what is the policy which demands an exclusive jurisdiction for the tribunal in Section 7(1)A cases, even though the High Court retains a jurisdiction in cases that may be just as intrusive, indeed more intrusive, into the activities of the security services. Because if the claim is for breach of confidence or for trespass or for nuisance, the court will have an original fact-finding jurisdiction, which may well be much more intrusive than a human rights jurisdiction, which involves a discretionary area of judgment. So that's the first supplementary point I wanted to make. The second supplementary point from this morning that I wanted to make is in answer to the question posed by my Lord Clerk, which was whether or not a claimant may have a rational reason for preferring to take the case before the tribunal rather than bringing a judicial review. And there are two reasons why the claimant may wish to do so. The first was touched upon by Mr. Miller, and that's Section 17 of REPA. Could I invite the court to go to the Appendix Part 1 at page 181, because your lordships will see Section 17 of REPA on page 181, which is the broadest of exclusion clauses, exclusion of matters from legal proceedings, 17(1), subject to Section 18, no evidence shall be adduced, question asked, assertion or disclosure made, or other thing done in or for the purposes of or in connection with any legal proceedings or Inquiries Act proceedings which in any manner, and then A and B deal with interception activities. So you simply cannot raise these matters, as I understand it, in the court, subject to Section 18. And Section 18 over the page tells us in 18(1) that Section 17(1) shall not apply in relation to C, any proceedings before the tribunal. So whatever the proper interpretation of section 65(2)(a), whether or not it confers an exclusive jurisdiction on the tribunal, any rational claimant whose case touches upon section 17 issues will choose to go before the tribunal because he's not going to get anywhere in the High Court by reason of section 17(1). There is also a second reason why a rational claimant may, depending on the facts of his case, choose to go before the tribunal, and that's because of Rule 11, which is on page 317 of the appendix. Page 317, Rule 11, 1, tells us the tribunal may receive evidence in any form and may receive evidence that would not be admissible in a court of law. Now, that would not only apply to evidence that is not admissible for mundane reasons, but as I understand it, it would also apply to evidence that would not be heard by the High Court because of a public interest immunity certificate. And no doubt it was decided that that was simply an inappropriate restriction in relation to the tribunal. And again, it would depend on the facts of a case, but a rational claimant may have a very good reason, based on Rule 11, for choosing to take his case to the tribunal, whether or not there's an exclusive jurisdiction for the tribunal. The third point that I just wanted to touch upon was the question put by my Lord Brown. And your Lordship's question was, as I understood it, was whether there was any helpful Article 10 case law in Strasbourg on the publication of national security material. Well, in my submission, the best case is Spycatcher, which the court has at volume 9, tab 83. I don't invite the court to turn it up. But at paragraphs 53 to 55, the court addressed and rejected the government's argument, undoubtedly an unusual argument, but an argument nevertheless, that there was a national security reason why the Sunday Times should not be allowed to publish the contents of a book which had been circulated in millions of copies throughout the rest of the world. But the government's argument was a national security argument, so described by the government. And the court considered and rejected that argument on its merits. And that shows that Article 10, it does not stop once an assertion is made of national security issues. It demonstrates that Article 10 reaches into the merits of such consideration, albeit, as I accept, a very extreme case on its facts. Those were the preliminary points. May I turn, my lords, to the tribunal's procedures? We say that there are serious breaches of human rights standards in the rules of this tribunal, and there are three of them. The first of them is that there is simply no adequate adversarial procedure. Claimants have no right at all to be informed of any part of the opposing case or to see any of the evidence which is relied upon by the intelligence services unless they, the services, give their consent or other relevant person gives consent. Can I show the court the rules? It was Rule 6, which my friend Mr. Miller read this morning, which is Appendix Part 1, page 314. Rule 6.1 on page 314 is the general obligation on the tribunal to protect the public interest and preserve national security, which I'm not challenging. The tribunal has that power. But notwithstanding the existence of that general power and duty, 6.2 goes on to say, without prejudice to that duty, but subject to 3 and 4, the tribunal may not disclose to the complainant or any other person, A, the existence of an oral hearing. I'm not concerned with that at the moment. B, any information or document disclosed or provided to the tribunal in the course of the hearing, or the identity of any witness at the hearing. Or C, any information or document otherwise provided, disclosed or provided to the tribunal by any person pursuant to section 68(6) or provided voluntarily by a person. And if one turns over the page, one sees what the exceptions to that are in paragraphs 3 and 4. Paragraph 3, the tribunal may disclose anything described in paragraph 2 with the consent of, and then A deals with the oral hearing. It's B and C that we're concerned with. In the case of subparagraphs B and C, the witness in question or the person who disclosed or provided the information or document. And the only other relevant exception is subparagraph 4, which Mr. Miller read. That deals with a case where there is a favourable determination, only a case where there is a favourable determination. So the fact of the matter is that this tribunal's rules provide that the claimant is entitled to see no document or information whatsoever about the case unless the person who provides the information, that's the security services, consents. And the tribunal is in that position whether or not it believes, pursuant to Rule 6.1, that there is a public interest or national security reason to deny them access to that information.
Can you just help on precisely how this argument works? We've been told that the tribunal, with its own motion, struck out one rule as being incompatible with the convention. How far does it get you to attack the rules? This is the clothing of the tribunal. You say we can't really look at the tribunal in isolation. We've got to look at it clothed with its rules.
The argument proceeds along this route that there are fundamental breaches of the rules, and yet the tribunal of Article 6, the tribunal has given a rule in which it has said that all of these rules, other than 9.6, are conventional ones. And the Act contains a provision which purports to exclude any judicial review of the decisions of the tribunal. And furthermore, a complainant will find it enormously difficult to bring a judicial review of an adverse decision, because, as I'll show this in the court in a moment, he's not going to be told anything about why he's lost.
Why didn't he give bring a judicial review anyway, can he? Why can't he? I mean, I thought...
No, it's excluded by...
Well, exactly. So why are we interested in what he could...
Well, because the argument that for anismic reasons, the exclusion provision doesn't mean what it says.
Well, it's not an anismic case. I mean, this is a body quite unlike the tribunal in anismic.
It's even worse, in my submission, if you know the judicial review rules of this tribunal, and if the procedures that have been adopted by the tribunal are themselves then we say that this court should be most reluctant indeed.
It's subsection 8 of section 67, this is, and that's wide enough, is it, to exclude judicial review of these very questions, or decisions on these very questions, namely, whether any of the procedures are themselves contrary to Article 6.
Why does that challenge, why does the challenge to the rules by judicial review have to be made initially before the tribunal rather than in the administrative court?
Your Lordship's envisaging some other form of challenge.
Yes, I mean, yes.
Well, then what one is envisaging some form of parallel proceedings that the individual who's told, as A is being told, bring your case, you have to bring your case before the tribunal, has to bring some form of satellite parallel proceedings before he starts in the tribunal, in which the High Court is going to determine whether or not the rules of the tribunal are consistent with Article 6. That, again, in my submission, would be a very odd way to resolve the problem, if it be a problem, of the rules not being convention compliant.
Surely 8, subsection 8 of section 67, doesn't apply. If it only applies to determinations, awards, orders and other decisions, and they're not to be subject to appeal or liable to be questioned. Well, if the tribunal simply erred in procedure, it wouldn't have made a determination, award, order or other decision. If its procedure was unfair, you could judicially review it. As I understand the tribunal's actual decision, what it has said, what is held, and I must confess I haven't read every page, but just looking at it, page 54 says, effectively, it's possible to read Rule 6.2 consistently with the right to give a fair hearing, but if it isn't, then it's invalid to that extent.
Where is that?
So, I mean, there are really 2 points. Firstly, your Annie's Minnick point doesn't seem to me a good one. And secondly, can't the tribunal actually read its own rules properly?
The tribunal has decided in this preliminary...
Which number is it?
tab 5, Lord.
Which page are we looking at?
Bundle 5, tab 40.
Tab 40.
Yeah.
Yeah, thank you. The page.
And what they've decided here, they decided that Article 6 is applicable. That was paragraph 85 of their decision. They decided that Rule 9, Sub-Rule 6, which I'm coming to, breaches Article 6 because it prevents them from having a public hearing and giving public reasons, even in relation to preliminary issues of jurisdiction. But they then decided that in all other respects, the rules are consistent with Article 6. One sees this on page 7 at paragraph 12. It's point C at paragraph 12. In all other respects, the rules are valid and binding on the tribunal, and they're compatible with Articles 6, 8 and 10 of the Convention, and they return to this later in the decision at paragraph 181 on page 74, where they say at paragraph 181, they conclude that the departures from the adversarial model are within the power conferred on the Secretary of State by the Act. A reasonable rule-making body having regard to the mandatory factors in 69(6) could properly conclude these departures were necessary, they were proportionate. The NCND policy, the procedures laid down in relation to these matters. So they approve all of the rules, and at 191, at the end of 191 on page 77, last 2 lines, in the circumstance there could be no publication of the reasons for legal rulings on preliminary issues, but so far as determinations are concerned, the tribunal is satisfied the rules are valid and binding. The distinction between information given to the successful complainants and that given to unsuccessful complainants, where the no confirmation, no denial policy must be preserved, is necessary and justified.
So these are a series of rulings.
Yeah.
Are they decisions within subsection 8?
Well, in my submission, it's very difficult to see them. They are rulings of the tribunal on issues that are argued before them. They address this matter themselves on page 7, paragraph 14, where they say in paragraph 14 in the 4th line on page 7, the responsibility of the tribunal is a particularly anxious one. It's not within the competence of many courts and tribunals short of the House of Lords to make rulings on questions of law apparently unappealable to and unreviewable by any other judicial body within the jurisdiction. So they, on their part, regard themselves as being the first and last judicial body
What about...
Mr. Emerson, for the complainant, obviously accepts it too, because it's a necessary precondition to going to Strasbourg that he's exhausted
precisely so.
domestic remedies. And he's challenging this decision and the compliance with these rules with the articles in Strasbourg.
He certainly is, and I'm not quarrelling with that. I'm simply submitting to this court that if the position is, as I submit it to be, the body which is said to have exclusive jurisdiction has procedures that are quite impossible to reconcile. And they why this court should not interpret section 65 so as to accord to that tribunal an exclusive jurisdiction.
But I mean, are you asking us then, Lord Panic, to preempt the Strasbourg decision with regard to the view expressed by the IPT as to the compatibility of its own rules?
That must follow from my submissions. It's part of my submission that this court should rule that these procedures are not Article 6.
But then you're yourself in breach of section 67(8), aren't you? Because you're questioning what you assert is a determination or decision of the tribunal.
Well, I'm not asking this court to review.
Well, that depends on the true construction of subsection 8.
I'm not asking the court to review. It's an incidental question, but an important one, in deciding whether this court should accord to the tribunal an exclusive jurisdiction. And my answer to Lord Brown is I don't see any way, with respect of the court not addressing that question. The court may say it's not for this court to decide it, but it's my submission that it is a vital question when the court is asked to confer an exclusive jurisdiction on a body, to ask whether that body operates under procedures which are convention compliant. And it does not for reasons which I would accept are in any way contentious, because my point under the rules, the first point I made, is not to suggest that there will not be many cases where it is perfectly proper to conceal information from claimants. My point is that the claimant cannot be given any information about the case against it by reason of Rule 6.2, even if the tribunal is satisfied under Rule 6.1 that there's absolutely no public interest reason or national security reason why it shouldn't be given the information. That is what is so bizarre in my submission about Rule 6.2 and Rule 6.3. It confers an exclusive jurisdiction on the security services to decide what should be disclosed. It gives no power to the judicial body to make up its mind on what can be disclosed. And that, I say, is striking indeed.
I mean, I see that, but I do find it still very difficult to think that the only body which can review the validity of the Investigatory Powers Tribunal rules, 2000, is the body whose rules they are. I mean, if they hadn't made a decision, coming back to the first point I put, if they hadn't had this elaborate decision, which you say is a decision within section 67(8), couldn't you have gone straight to court and challenged the vires of these rules?
Well, the challenge to the Secretary of State's decision to make
Yes, exactly.
I see the force of that. I anticipate what would have been said against such an application is that this matter has already been determined. The President were to do that now, or rather Mr. Miller were to do it now. It would be said, well, the tribunal's ruled on this. The tribunal is, because this court would have said so, the exclusive body with jurisdiction in this area. And there's a specific statutory provision, 65(8), that says no judicial review.
Well, that depends upon how narrowly you construe subsection 8. I mean, if you test it on the hypothesis that proceedings have been begun for some kind of declaratory relief before the tribunal expressed a view, then you wouldn't be stuck with subsection 8. So the court would certainly have had jurisdiction, to my mind, if it had happened, to get in first, because there'd be nothing on the true construction of subsection 8 to lead to any other conclusion. And it might be that, given that, since that's the case, that all subsection 8 is about challenging specific decisions in a specific case, and wasn't intending to remove from the court any jurisdiction it might otherwise have had to make decisions in relation to whether or not the rules were compatible with the convention.
I understand. It's very difficult for someone in the position of A, who of course has no interest in challenging these rules, unless and until he comes into conflict with the security services because he wants to publish his book. And by the time he comes to the point where he's interested in the rules, the tribunal has already ruled. It is some years since the rules were made, and he will inevitably face the most difficult of tasks in persuading the High Court now to entertain a judicial review application in relation to the rules. So we are in a bizarre situation.
I would have thought, I mean, if the tribunal has ruled, but in another case, if it set off down a procedural course which was unfair, it wouldn't actually have made any determination or decision in the particular case. I would have thought there was no reason why he shouldn't subsequently, when it's ultimate, challenge the procedure either before or after it gives its award. Couldn't it? By going to court, I mean, you say, obviously, there are all sorts of arguments that arise, but I think you'd be arguing contrary quite forcefully if that situation arose.
Well, he faces the great difficulty that this whole scheme of these rules is designed to arrive at a result whereby the tribunal, the judicial body, plays no role in deciding whether or not disclosure can be made of anything. And that in my submission, is a remarkable position. If A goes before the tribunal and he argues that point and he loses, he does then, because there will be a determination, he does then face the 65-8 problem. Can he bring a review of that part of the decision? And can he bring it in the context that he will be bringing a potential judicial review, notwithstanding the problem of 65-8, but also in the light of the second procedural unfairness, which is that he's not told anything at all about why he's failed in his substantive case before the tribunal. This is the second aspect of the tribunal procedure, which we say is the plainest breaches of Article 6. He's not given any reasons at all. This is section 68(4) of the legislation, which is on
page 266.
Where the tribunal 68(4), where there's determined proceedings, complaint or reference brought before or made to the complainant, which shall be confined, as the case may be, to either a statement that they've made a determination in favour, or a statement that no determination has been made in his favour. And that is only subject to any rules made by virtue of section 69(2)(I), which gives a power to say more than that. And then we go to the rules, and they are rules 13, 1 to 3. Rule 13 on page 318. In addition to any statement under section 68(4), that's new law, the tribunal shall provide information to the complainant in accordance with this rule. When they make a determination in his favour, they give him a summary. When they make a determination that he's lost, they shall notify the complainant of that fact. And they say at 4, the duty to provide information under this rule is subject to the general duty under 6.1. Now again, this is remarkable, because even if the tribunal does not think that the considerations in Rule 6.1, that is public interest or national security, require no details to be given, no details shall be given. And that is quite remarkable. It means that there's no attempt by the tribunal to give what one finds in a controlled context, or a SIAC context, some form of closed without damaging national security. Again, this whole procedure depends upon an assumption that the judicial body has no role, no responsibility for disclosure, for deciding what information can properly be disclosed. There's a third aspect, very similar to the second, which is that there is no public pronouncement of any judgment whatsoever, subject only to the tribunal's ruling, which the court has seen, volume 5, tab 40, that it will give judgments on preliminary issues of law. But it gives no judgments, and it has decided it will give no judgments on any questions as to merits.
Is it prohibited from doing so?
It's prohibited from doing so by 9.6.
Well, the proceedings shall be conducted in private. That's 9.6.
Yes, but it must also follow from section 68, 4. And it must also follow it follows from Rule 6.2, because they may not disclose to the complainant or to any other person any information. So that must cover a public judgment.
Yes.
I make the same point. I entirely recognise and accept, of course, a tribunal of this sort must have a power to decide what must be redacted, what it is damaging to public interest, considerations or national security to tell the public. But the idea that you have a tribunal which publishes no judgment of any sort explaining at all what it has decided and why is fundamentally inconsistent with the basic requirements of Article 6 of the Convention.
I mean, what perhaps you might say is that, I mean, it's perfectly understandable in all those cases where actually the intelligence agencies doing their ordinary jobs either are going to be authorised or they're not, and you can't confirm and you can't deny. And if the chap loses, you mustn't tell him, well, you've lost because actually they haven't the faintest interest in you, or you've lost because they have, but they have good reason. And so that's the basis of the rule. But I mean, really what I suspect you have to say, Lord Panic, is that really, therefore, that simply supports the view that the regime oughtn't to apply as widely as, of course, on the respondent's case, it does apply to every single 7-1 case.
Well, that is precisely the submission, and I hope it supports my friend's arguments. This is far too broad a regime if the respondent's argument is, and it is, that there is an exclusive jurisdiction for this tribunal in relation to all the matters that are covered. What I entirely accept is that even if in principle judicial review does apply, there is jurisdiction in the judicial review court, there will be many, many cases where it is obviously inappropriate for the judicial review court to entertain the application, because it does depend on matters that the tribunal may be a much more effective body to determine. And it is, if I may say so, trite judicial review law that the High Court will simply not entertain an application where there is an equally effective, or indeed more effective, alternative remedy. And I don't accept that this is simply a question of the High Court hearing the case and then saying we won't give you a remedy, Mr. A. It is rather a matter of the High Court having jurisdiction, but in this type of context, the claimant in the judicial review having to satisfy the High Court, as he satisfied Mr. Justice Collins, rightly or wrongly I don't comment on, but as he satisfied Mr. Justice Collins, that there were very good reasons for bringing this case as a judicial review and not bringing it before the tribunal. And that's as far as my submission goes, that the High Court does have jurisdiction. The tribunal does not have an exclusive jurisdiction, but the High Court will certainly not wish to hear all of the cases in respect of which the tribunal does enjoy jurisdiction.
But isn't there a problem with that? Because, I mean, that's assuming that it's going to be brought in by way of judicial review, which, of course, is a discretionary jurisdiction and all the rest of it. What happens if he brings it in the county court, or he brings some common law action in the Chancery Division?
There are analogous doctrines. There's the doctrine of abuse of process, for example. It may be said that where there is a specialist tribunal established by Parliament to hear a category of complaint, and where the applicant chooses to bring his complaint in the county court instead of going to the tribunal, in circumstances where, if he had brought it by way of judicial review, the High Court would certainly not hear it, it is an abuse of process, unless there's a very good reason.
But like no reasons,
I'm sorry.
like all the human rights points you make. I mean, those points would be available in every case.
Yes. There may be a reason why that is so. And so I say that given that this tribunal has already decided that its procedures are convention compliant, given that that decision for Mr. A and others like him is simply not a decision that he's going to be able to challenge by way of judicial review. In other words, the tribunal is going to have the last word within the domestic system. And in any event, Mr. A, if he goes before the tribunal, will not know why he's lost, which will make it very difficult for him to bring any effective judicial review. We do submit that in the context of human rights claims, which is what we're talking about here under Section 7.1a, Parliament simply cannot have intended that a person must be required to use a procedure which is itself fundamentally inconsistent with basic human rights. This is a tribunal which has no power itself to decide on what should be disclosed and what should be told to the public.
So you say it's all at the option of the claimant. In every case, you support construction too.
Subject to the control of the administrative courts or the county courts, which will start, I accept, from a presumption that it is necessary, and this is on the basis of standard judicial review principles, there is another remedy. The claimant would have to satisfy the judicial review court that it is not an effective remedy or an equally effective remedy, and therefore judicial review should apply.
But if you're right that the tribunal system is flawed as being contrary to these fundamental rights, that's what the claimant will say in every case. And how can the court say, if we say, and I understand you're asking this court to say, that the tribunal system is contrary to these fundamental rights in two or perhaps three ways. Now, if this court says that, then in every case, the principle, whatever it is, whether it's judicial review or county court and abusive process, if the defendant were to say, well, this is an abusive process, the answer would be it's obviously not an abusive process, because what that means is that I've got to take my case before a tribunal, which the Supreme Court has held is contrary to my human rights. That'll be the end of it.
No, I understand that. The answer to your Lordship's question is that it will depend upon the particular facts of the particular case, whether the divisional court can be satisfied that this is the type of context, Article 10, for example, where the role of provision of information to the claimant and a reasoned judgment of some sort has a value, or whether it's a more mundane but important issue that turns and only turns on some fundamental national security issue, which of course none of it can be disclosed to the individual.
So no breach of human rights, no breach of Article 6 in those cases?
I wouldn't make that concession. No. I wouldn't make that concession even in that case.
Lord Pennant, can I come back to my point, which I don't find easy? These rules were introduced were laid before Parliament 2 months after, I think, the Act came into effect. Realistically, the whole lot must have been drafted as a package.
Yes.
But is it right that we should approach the tribunal having regard to the rules in which it was clothed, when what we're concerned with is an issue of how do you construe the Act?
I understand.
Or should we just be construing the Act with there's going to be a special tribunal and it's got to make appropriate rules which, insofar as it can do so, will satisfy the Human Rights Convention?
Well, Lord Justice Dyson in the Court of Appeal proceeded on the basis that this is a package and that the content of the rules are relevant to the interpretation of the statutory provisions, section 65(2)(a). He says that at paragraphs 47 to 48. It's also right that as a matter of principle, there is authority in the appellate committee that rules may be used as an aid to the construction of a statute, and there are limits to that, but it is not right to say that the proper construction of a statute cannot be assisted by the content of the rules which are made under it. The authority is Lord Lowry's speech for the House in Hanlon and Law Society. I apologise, we don't have it here today, but it's 1981.
Again, Hanlon, did you say?
Hanlon, yes, H-A-N-L-O-N against Law Society. The reference is 1981 appeal cases, page 124, in particular at 193 to 194. He deals with that. We can bring copies tomorrow for your lordships.
It's a slightly strange idea, though, because the Parliament doesn't have the rules in front of it.
No.
Does it? I mean, presumably the order of events is that they can only be laid after the Act has been brought into effect, once it's been commenced.
No,
so you know there's a rule-making power, and you can see the scope of the rule-making power, and you can make assumptions about it, but you don't know the precise content.
What one can say is that the legislation conferred a very broad discretion on the Secretary of State to make rules, and that one can say that it was the intention of the legislature when they enacted Section 65(2) that the Secretary of State, in relation to this tribunal, would be making rules which do whatever he thought was necessary to protect national security and the public interest. And I do say that one can have regard to the content of the rules that were made in assisting on the question of whether Parliament really intended to compel claimants to bring their cases before such a tribunal, whatever the content of the rules that the Secretary of State may have thought it right to make.
Doesn't your argument...
Security.
Sorry, I don't.
No, please.
No, I do apologise.
No.
I mean, doesn't the argument get back to front in another way, though? It all depends upon an assumption or presumption that Parliament must have intended a narrow construction of Section 65(2)(a) because the rules are so horrendously in breach of the Human Rights Convention. But Parliament can hardly have realised that the rules were in breach of the Human Rights Convention. Parliament can... I don't know whether there's a procedure when you put rules in front of Parliament for certifying that they comply with the Human Rights Convention. There isn't. But anyway, Parliament presumably didn't think that they were in breach of the Human Rights Convention, and therefore...
I see the force of that, but I've given my answers the best I can to whatever. There's one other way of looking at it, which is to look at it not as a question of the intentions of Parliament, which raises precisely the concerns your Lordship puts to me. The other way of looking at it is to say, is it a breach of Article 6 to compel the litigant in the position of Mr. A to bring his case before a tribunal which in fact has rules which are so flagrantly a breach of Article 6. It is true, and my friend Mr. Crowe has pointed this out in his printed case, the Convention does not require any right of appeal or review generally, but we do say that where the tribunal is itself in breach of Article 6, and when there are at least fundamentally difficult barriers to surmount before you could challenge the ruling of the tribunal in the higher courts, or indeed in this court, it is a breach of Article 6 to say to Mr. A, you can only bring your claim, your Article 10 claim, before a body which is not really a judicial body at all, because it can't publish its judgment in any circumstances other than preliminary issues, and it can't give you any information, even if that information does not need to be concealed for national security reasons.
Isn't that another way of saying exactly the same thing?
Well, it is, except I hope that it's an answer to the question put to me by my Lords Lord Manson and Lord Hope about the difficulty of statutory, of the intentions of Parliament. Putting it in terms of Article 6 focuses on the Human Rights Act and the need to construe the Section 65 consistently with the Human Rights Act, and it doesn't get deflected by the difficulties of chronology as to what Parliament may have known at any particular time. That's why I put it in that alternative way. Lords, I'm very grateful to the Court for listening to Justice. Unless I can assist further, and noticing the time,
Yes.
those are essentially the submissions I wanted to make.
Thank you very much, Lord Panic. We're grateful for
Can
that.
I ask your Lordship's indulgence tomorrow if I can't be here tomorrow afternoon, because I may need to be elsewhere tomorrow afternoon? Would your Lordship excuse?
Yes.
Something to argue about. Fascinating case.